Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. From case management systems to AI note-takers, law firms have more access to technology now than ever. Growing in 2026 requires finding that sweet spot where you're getting the most out of your tools and your team. On March 26th, leaders from e-Immigration and Staffy are hosting a free webinar on finding the balance between tech and talent. They'll cover what to automate and what to delegate, and how to grow your firm without overwhelming your people. It's practical, it's free, and it's built for immigration professionals. Register at eimmigration.com/events or click on the link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, loyal listeners. This week, the TPS saga continues in a big way. The government's cert petition was granted in our Haiti case and the Syria TPS case. Excellent litigators will be arguing for both cases over a 1-hour time allocation in late April. Jurisdiction, Ira's McNary win from decades ago, and the lives of 1 million human beings, and more, all hang in the balance. Hey, don't get me wrong, this is why we're attorneys, right? But I also look forward to a time when immigration isn't like every week on the verge of some momentous and intensely destabilizing change that risks destroying hundreds of thousands of lives. Also of note this week, the Sixth Circuit affirmed the conviction of former ICE agent Andrew Golubic. Mr. Golubic decided who would and who would not get detained by ICE at a local field office, places that myself and so many of you have been to often. Mr. Golubic, quote, used that authority, regrettably, to coerce immigrants to have sex with him. Mr. Golubic impeded investigations into his behavior by exchanging lenient supervision measures for other supervisees' silence and by destroying evidence, end quote. His conviction and sentence were affirmed precedentially by the Sixth Circuit. 5 cases for you all this week, so if you're already listening, listen some more. Starting off with United States via Aguayo-Montes, published by the 10th Circuit on March 17, 2026. This case is about ineffective assistance of counsel. But not in the usual way. Mr. Aguayo was brought to the United States when he was just 2 years old and has lived in the United States ever since. He received DACA at 16, likely right when the Obama administration began it, but I'm not sure. He graduated high school with honors and attended college in the United States, but dropped out after his parents divorced. He owns a home in Denver, and he's in a committed relationship. But he's definitely dabbled in drugs, something that many U.S. citizens do in this country as young adults with little to no consequences. Mr. Aguayo's problem is larger. In June 2021, he and his partner were driving through Utah when police stopped them under suspicion of criminal activity, apparently. His partner admitted that they were carrying drugs for a cartel. The partner said that, quote, cartel members had instructed her to abandon it or they would kill her and her family, end quote. I imagine at an arranged location so they could pick it up, but I don't know. It was 16 pounds of heroin. So this partner, whom Mr. Aguayo was in a committed relationship with, was carrying the drugs. But Mr. Aguayo was very much involved, it seems. It seems he was driving and helping her out. Prosecutors charged him with 1 count of felony possession with intent to distribute under 21 U.S.C. Section 841A1. That is a federal crime, of course, and it's pretty much a listed aggravated felony at I&A Section 11843B, a drug trafficking aggravated felony. And because it's federal, there can be no argument regarding like a mismatch between the drug schedules, right? It's the same federal drug schedule. Mr. Aguayo was most concerned about what this conviction would do to his rights to remain in the United States. He became even more concerned when, reading the standard federal court plea form, that form advised him that he, quote, may be removed, end quote, and denied admission in the future based on this conviction. But his criminal attorney was no help. Counsel told him, quote, he was not an immigration attorney and could not tell him what would happen, but that Mr. Aguayo didn't need to worry about that until he got to prison, and once he was in prison, he could contact an immigration lawyer, end quote. By the way, this is all being litigated in federal court to try to get out of this conviction, this plea. And to suffice for the facts, this is simply an attorney's motion containing these facts sworn to by Mr. Aguayo. That sufficed. Query why case law sometimes seems to make different rules in similar contexts in immigration court, and whether that's bad law in the 10th Circuit, or based on other decisions where it is sufficient for federal court, like here. Again, this is not even technically a sworn affidavit from Mr. Aguayo. This is a sworn motion that his attorneys wrote after speaking with him. Anyway, the whole wait until you actually have the conviction and are in prison was bad advice. A federal drug trafficking conviction is almost surely going to be an aggravated felony that not only will result in Mr. Aguayo's removal, but will bar him from returning to the United States for life. Now, he swore in these timely filed proceedings to get that conviction vacated that he wouldn't have pled. He would have rejected the deal if he had known. The court, the forum, and even the attorney to an extent all told Mr. Aguayo that his guilty plea could result in his removal. Not good enough under the Supreme Court's Padilla decision, explains the 10th Circuit, overturning the district court below. Violated his Sixth Amendment right to counsel, given that it was ineffective assistance as understood by Strickland v. Washington. That test that applies everywhere else in American law except in immigration, which is totally discriminatory and wrong. That is, that it doesn't apply in immigration, not Strickland v. Washington. That test is fine. Mr. Aguayo made a sufficient ineffective assistance showing, given his sworn attestation that, quote, his attorney both undersold and affirmatively misled him about the immigration consequences of his conviction, which led him to accept a plea deal he otherwise would have rejected, end quote. Overly equivocal advice of the immigration consequences does not cut it. Agreeing with decisions out of the 8th and 9th Circuits, United States v. Ramirez-Jimenez out of the 8th, and United States v. Rodriguez-Vega out of the 9th. Small world, too, that precedential 9th Circuit case involved an individual, Ms. Rodriguez-Vega, who is now a U.S. citizen and who, it turns out, I have on personal authority, is a wonderful nanny, should you ever need one in the San Diego area. Small world. Anyway, after all, the Padilla court recognized that, quote, avoiding deportation, a severe consequence equivalent to banishment or exile, is of the utmost importance to non-citizens facing criminal charges, end quote. That includes not just removability, but preserving the option of discretionary relief from removal, too. Quote, to vindicate those interests, counsel must correctly assess immigration consequences at the onset, when she may be able to plea bargain creatively with the prosecutor in order to craft a conviction and sentence that reduce the likelihood of deportation, end quote. But immigration law is also crazy complex, the 10th Circuit explains. As such, the Supreme Court in Padilla explained that criminal defense attorneys, quote, need do no more than advise a non-citizen client that pending criminal charges may carry a risk of adverse immigration consequences, end quote. But then again, quote, when the deportation consequence is truly clear, the duty to give correct advice is equally clear, end quote. We've narrowed the question then, right? Were the consequences of Mr. Aguayo's conviction truly clear? They were, says the 10th Circuit. And that's me doing my best Marissa Tomei impression. Pretty good, right? And they were not least of which because Padilla itself was a drug case. Given that, the attorney's advice was insufficient. And the standard federal court form about how the conviction may result in removal doesn't save the criminal defense attorney or absolve him or her from their obligations. Counsel needed to convey, quote, automatic deportation, end quote, to Mr. Aguayo. Counsel did not, and so was constitutionally ineffective. Now, 2 years later, the Supreme Court issued its Chavez decision, which the government here argued clarified that competent counsel need only advise of the risk of removal. Quote, but advising a client about a risk means more than just noting its existence. At the very least, competent advice about risk includes both recognizing that a risk exists and offering a qualitative assessment of that risk, end quote. Particularly when the risks are clear. Tread carefully, criminal defense counsel. Lots of pages about why this is so, why other circuit authority is actually on Mr. Aguayo's side, and additionally, batting down other of the government's arguments. Quoting the 9th Circuit, the 10th Circuit agrees that, quote, warning of the possibility of dire consequence is no substitute for warning of its practical inevitability, end quote. Or how about this morbid analogy, quote, I know every time that I get on an airplane that it could crash, but if you tell me it's going to crash, I'm not getting on, end quote. Enlightening though, right? The criminal defense attorney also affirmatively misled Mr. Aguayo. Quote, by telling him he didn't need to worry about immigration consequences until he got to prison, counsel actively misled Mr. Aguayo about the decision he faced, end quote. That the government or even a federal judge may have put in other things in the plea agreement is, quote, simply irrelevant to the question whether counsel's performance fell below an objective standard of reasonableness, end quote. Pretty big stuff. And it all prejudiced Mr. Aguayo. Or it might have. That'll be up to the district court to determine if there was a reasonable probability that with effective counsel, he wouldn't have pled guilty, even if, quote, not everyone in Mr. Aguayo's position would make the choice to reject the plea, end quote. Pretty important standard. So, of course, while not an immigration case per se, pretty important to an ineffective assistance of counsel claim in many contexts and to working with criminal counsel to try to get your client's conviction vacated. And so, congratulations to Benjamin C. McMurray and Scott Keith Wilson of the Salt Lake City, Utah Federal Public Defenders for the victory. And that is United States v. Aguayo-Montes. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. doing business as Invest America. 2 from the BIA this week, our first case being matter of Arevalo-Vargas, published by the BIA. This case is about non-LPR cancellation of removal. It used to be non-precedential, but the Attorney General made it precedential. Been a couple of weeks since we've seen that fun procedural move. Welcome back! Mr. Arevalo-Vargas is from Mexico, has lived in the United States for a long time, and has U.S. citizen children. He applied for non-LPR cancellation of removal when placed in removal proceedings. An immigration judge granted the relief. DHS appealed. The BIA appeal took so long that both aged out while on appeal. One is now 26 and the other is 24, so this appeal must have taken a very long time, right? Like at least 6 years. So then at the onset, and surely the reason for this decision's publication, the BIA states, quote, "As an initial matter, the respondent's children are no longer qualifying relatives for purposes of the respondent's application for cancellation of removal because they aged out during the pendency of this appeal." End quote. BIA is a bit late to the game. That is now flat out bad law in the Sixth Circuit, Perez v. Bondi, episode 292. Seems just so improper too, right? As it gives DHS an effective veto over a significant swath of cancellation grants simply by appealing, just like they did in this very case. Petition for review for days, folks. Having dismissed the appeal for that reason, and perhaps recognizing that a petition for review may follow, the BIA goes on to explain in the alternative how actually the hardship was insufficient, overturning the immigration judge on de novo review. Trying pretty hard to limit matter of Racinus' applicability with a parenthetical, too. In part, that is because, quote, "the record contains no evidence that the respondent's children have any serious medical or academic issues," end quote. At least one of the reasons relied on by the IJ to find hardship was that the 2 children, then teenagers I assume, would have to get part-time jobs while in school without their father. Quote, "However, economic and educational hardship of this nature is a common feature of a parent departing the United States," end quote. Nor is there evidence that Mr. Arevalo-Vargas would be unable to find employment in Mexico. To the extent it's going to hurt the kid's college prospects, quote, "the respondent has not established that the possibility that his children have to contribute to their post-secondary education is an uncommon practice that necessitates his continued presence," end quote. Pretty roundabout way of making that holding. Regarding emotional hardship to the now adult children, the wife is remaining in the United States, explains the BIA, and, quote, "as significant of a hardship as family separation is," end quote, "it doesn't cut it." At least alone, I imagine, is what the BIA means. And no mention of the wife's status. And really, that's it. And that is matter of Arevalo-Vargas. Moving on, we have matter of ZRCN, published by the BIA. This case is also about ineffective assistance of counsel. Kind of. This case, too, used to be non-precedential, but this time it was the BIA that decided to make it precedential after the fact. What happened? Attorney General not available? Miss ZRCN was ordered removed and then had her appeal dismissed in May 2025. She filed a motion to reopen based on ineffective assistance of counsel, it appears. This BIA decision denies that motion. So the story goes. Miss ZRCN hired a Mr. Chavez to represent her and her family in removal proceedings, to file an asylum application, and to apply for work authorization. She thought he was an attorney. He wasn't. Not only did this Mr. Chavez tell Miss ZRCN not to mention harms that she had suffered from her ex-husband in the I-589, but of course he never represented her at a removal hearing because he's not an attorney. Doing it all pro se, Miss ZRCN lost. Then this Mr. Chavez took her money to file an appeal with the BIA. Turns out he never filed an appellate brief, as he was hired to do, although he's not an attorney, so what's he going to do anyway? And Miss ZRCN was only told this when she spoke with an attorney to inquire into a special immigrant juvenile classification for her daughters. Naturally, Mr. Chavez never looked into the SIJ eligibility either of those derivative daughters. Current counsel got a state court to grant SIJ classification in April 2025, and USCIS approved the I-360s a week later, putting the daughters on a potential path to LPR status. Though they wouldn't get continuances if they were in removal proceedings, right? We learned that from the BIA just last week. But anyway, everyone's got these removal orders now. To reopen them, current counsel alleged ineffective assistance of counsel against a non-attorney notario-type character who preys on foreign-born communities. Now, off the bat, the BIA does assume arguendo, quote, that ineffective assistance of counsel claims can be brought against a non-attorney, end quote. Under the right circumstances, I suppose. These just aren't those, to the BIA. Apparently, Ms. ZRCN didn't actually say with her motion that Mr. Jerez told her he was an attorney. She just assumed it, says the BIA. Also, the BIA doesn't think that Ms. ZRCN actually thought Mr. Jerez was an attorney, given that she appeared in immigration court and said she didn't have an attorney after she hired him, and Ms. ZRCN didn't even bring him up. As such, quote, she has not established she reasonably believed Mr. Jerez was an attorney, end quote. But if she did, this decision might be different. Then, as such, here's a new rule, quote, a respondent cannot succeed on her ineffective assistance of counsel claim where the individual she hired was not an attorney and did not hold himself out to be one, end quote. In any event, the BIA doesn't believe that Ms. ZRCN has established prima facie eligibility for asylum, which I suppose it believes means she didn't establish prejudice from any ineffective assistance. After all, with the Attorney General having vacated matter of ARCG since Ms. ZRCN filed her motion, the BIA believes that, quote, Ecuadorian women in a domestic relationship who are unable to leave the relationship, end quote, is, quote, circular and defined by the harm or threatened harm, end quote. Nor to the BIA did Ms. ZRCN establish that her family group was socially distinct, citing to matter of LEA in a holding that might not be such great law in lots of circuits. But in any event, moving on, the BIA also doesn't believe that Ms. ZRCN established a nexus to a protected ground. Though I'd remind everyone, we're in prima facie territory, not establishing an asylum claim, right? But really doubling down on matter of AB now and not citing to any circuit precedent for this asylum stuff, the BIA states, quote, domestic violence perpetrated by private actors generally does not constitute harm on account of a protected ground, end quote. Turning then to the minor respondents who have approved SIJ petitions that could permit them to adjust to green card status. Well, as we know, there's like a 4-year backlog at present. As such, quote, the minor respondent's eligibility for adjustment of status based on an approved special immigrant juvenile petition is speculative, considering the 4-year delay in a visa availability, and they have not demonstrated prima facie eligibility for relief, end quote. Although I'm not quite sure what that means with the I-360s approved, but I don't know, maybe they want the I-360s that were filed with USCIS and a completed I-485. Believing these facts not exceptional enough, the BIA also declined Ms. ZRCN's request to reopen proceedings sua sponte, all but ensuring this family's removal from the United States. And that is a matter of ZRCN. Next up is Hodzic v. Bondi, published by the First Circuit on March 19, 2026. This case is about reopening and reconsideration. Ms. Hodzic is from Serbia, and her husband, Redzo, is from the Republic of North Macedonia. Both are Bosnian Muslims. Seems they were both born in Yugoslavia, which of course no longer exists, and both lived in the Serbian region during the Bosnian genocide of Bosnian Muslims, known as Bosniaks, in the mid-1990s. They fled Serbia in 2000 because of the war and the fear of the Serbian government. They were pregnant too at the time. They entered the United States using forged Slovenian passports, but came clean pretty quick in the airport and sought asylum, which eventually led them to removal proceedings. The notices to appear didn't have the date and time of their first hearing in violation of the INA. But they made it to that first hearing and sought asylum. An immigration judge eventually denied that application in March 2002. The BIA affirmed, and then they petitioned for review, but then they voluntarily dismissed that petition for review in 2006. Because you see, somehow they believed themselves eligible to adjust to LPR status. I don't know how, but DHS must have too, because they joined a motion to reopen, and it was sent back to the BIA, and then the BIA reopened and remanded it to an immigration judge who terminated proceedings. But then at that adjustment interview, USCIS denied it based on a fraud finding. Remember, those false Slovenian passports that, if we're being generous, were used out of fear for their lives? So back to immigration court they landed, where they were ordered removed again by the IJ and then the BIA, and then they had a motion to reopen denied too. In July 2021, they filed a second motion to reopen, this time based on Niz Chavez and that deficient NTA. Remember that fact? The deficient NTA? The Hodzics argued then that the stop time rule was never triggered, and that by then they had accrued more than 10 years continuous physical presence necessary to apply for non-LPR cancellation of removal. Which is totally accurate. And in a footnote, it seemed that there is quite a legit hardship claim to a U.S. citizen child. The BIA denied for Lord knows what reason. This decision here isn't clear, but that argument is on all fours with matter of Chen, albeit a decision issued by the BIA after they denied the case here. But then why deny the motion to reconsider in 2024? We're about to find out. Candidly, I'm not sure why this is a sua sponte motion to reopen rather than a timely statutory one with an equitable tolling argument asserted, but the First Circuit sees what's going on as a sua sponte motion. And here's why. Because the Hodzics filed that motion to reopen years before the first motion to reopen, remember? Silly Kevin. You only get one motion to reopen, and the Hodzics used it years before their Niz Chavez-based one, it seems to me. Pretty rough. Regardless, and whatever the reason, we're in sua sponte reopening land, which is a near no man's land for petitions for review. Now, not for nothing, the First Circuit recognizes that it does have, quote, limited jurisdiction to review BIA denials of motions to reopen sua sponte when these are premised on legal or constitutional error, end quote. Without deciding whether that was really what was at issue here, the First Circuit denied the petition for review on the merits. 4 arguments too, and we'll take them in turn. First, sua sponte motions to reopen require a showing of an exceptional situation. The Hodzics argued that the BIA applied a heightened standard, but the First Circuit disagrees. Just what is an exceptional situation is largely at the BIA's discretion, it would appear to me. More importantly, it's not the same thing as exceptional circumstances, that statutorily defined phrase used for other statutory kinds of motions to reopen. Love the argument, though, counsel. So the BIA's failure to use that standard, though, can't be legal error because they're different standards, explains the court. Nor was the denial of the motion to reopen arbitrary and capricious for failing to provide a sufficient explanation. That was rejected because the Hodzics relied on decisions where the First Circuit overturns a BIA appeal, not a sua sponte reopening denial. It seems like the First Circuit requires more details from the BIA when they're denying an appeal, but not so much for a sua sponte reopening denial. Moving on, the Hodzics argued that the BIA failed to determine that Niz Chavez was a fundamental change in law that warranted reopening as an exceptional situation. Problem is, that the BIA decision they relied on, matter of GD, only says that the BIA may reopen sua sponte based on a fundamental change in law. Not that they have to. And assuming, of course, that Niz Chavez is fundamental, which, let's be honest, it is. Concluding then with a Loper Bright argument. The Hodzics argued, at least the First Circuit reflects they argued, that the court shouldn't defer to the BIA here, but there's a problem with that argument to the court. Loper Bright's about no longer deferring to interpretations of ambiguous statutes like the INA, but sua sponte reopening isn't about that. This whole dispute here is about the BIA's regulatory-based, very discretionary authority to reopen or not sua sponte. As so framed, those were the 4 claims, and they were rejected. Now, there was also a claim of constitutional error, actually. First, the Hodzics argued that the lack of, quote, reliability in the BIA's sua sponte determinations deprived them of procedural due process, end quote. And second, they claimed that the BIA violated their substantive due process rights to family integrity or familial association. Interesting stuff. Problem is on the former that the First Circuit and most, if not all, circuits have held that, quote, the BIA's exercise of its purely discretionary sua sponte authority does not create a cognizable liberty interest, end quote. Without a protected liberty interest, you can't have a procedural due process claim, explains the court, so the argument is dead, the first one. As to that second substantive due process-based argument, well, quote, the Hodzics only referenced the right to family integrity in passing, end quote, in their legal briefs, and so the First Circuit deemed the argument waived. Too bad, though, especially because the First Circuit states that, quote, parents have a fundamental liberty interest in the care, custody, and control of their children, end quote. I can feel my future wheels turning. It did not save the Hodzics, though. And that is Hodzic v. Bondi. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. The skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.pen-and-swordkc.org or at the special links in the show notes. Use special code Immigration Review 26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. I know you don't want to leave, but we must. Go listen to Pod Save America or something after this, I don't know. Our final case is Hassan v. Bondi, published by the 7th Circuit on March 16, 2026. This case is about mens rea for theft-type aggravated felonies. Ultimately, we will have to wait another day for resolution of this case, though. Here's why. Mr. Hassan is a lawful permanent resident, but in 2019 he pled guilty to attempting to receive stolen property in violation of Kentucky law. That's KRS sections 514.110 and 506.010. DHS alleged that was an aggravated felony as defined in INA section 101A43G. Mr. Hassan moved to terminate, and an immigration judge agreed that it's not an aggravated felony, and I guess terminated. But ICE appealed, and the BIA disagreed. Somehow that got to the 7th Circuit without first going back to the IJ on remand? Maybe Mr. Hassan wasn't applying for relief? Can you just petition for review a removability finding by the BIA with relief possibly pending before an IJ? I'm almost positive you can't. But in any event, here we are. Now, receipt of stolen property is a listed aggravated felony. But it, like classic theft, requires as an element the, quote, taking of property or an exercise of control over property without consent with the criminal intent to deprive the owner of rights and benefits of ownership even if such deprivation is less than total or permanent, end quote. And with receipt of stolen property offenses, Oyl and Mr. Hassan agree that the statute must require a, quote, subjective knowledge or belief that the property was stolen, end quote, quoting the 5th Circuit and the BIA. So what does this Kentucky statute require? Well, by the text, it requires that a defendant at a minimum have, quote, reason to believe that it has been stolen, end quote. Given that that is listed right next to actual knowledge in the statute, both could be sufficient, right? Actual knowledge or reason to believe. That must be a lesser showing than knowledge, right? Seems pretty strong for Mr. Hassan that the mens rea is deficient. Plus, quote, various federal courts have suggested that a criminal defendant can have reason to believe that something was stolen without having a subjective knowledge or belief on the point, end quote. Even the BIA appears to have said so in matter of Dieng. But yet still, the Seventh Circuit isn't sure what the Kentucky Supreme Court would say on the matter, having gone through some Kentucky decisions. Some of those Kentucky Supreme Court decisions support a conclusion that Kentucky requires constructive knowledge, quote, the knowledge someone should have acquired through reasonable diligence, end quote. But that's not actual knowledge, and it appears would be insufficient to the Seventh Circuit for the aggravated felony. Then again, another Kentucky decision seems to indicate that actually, quote, deliberate ignorance, end quote, is the lowest mens rea allowed. That is, that a jury finds, quote, beyond a reasonable doubt that he believed it was highly probable that the relevant fact was true, and that he took deliberate action to avoid learning that fact, end quote. If so, that would make the Kentucky conviction a match to the aggravated felony mens rea. But still there's more. Wait till I get going. This is actually called the ostrich defense. You know, putting your head in the sand. But perhaps the Kentucky version of the ostrich defense is different than the federal version. So maybe there's not a match. And you would have counted on that, so I can clearly not choose the wine in front of me. Wait, wrong story. My bad. Back to Mr. Hassan. Given that it's all unclear and it doesn't want you to put a cup of iocane powder in the Kentucky Supreme Court's mouth, metaphorically speaking, the Seventh Circuit respectfully certified the mens rea question to them so that they, the Seventh Circuit, could resolve Mr. Hassan's petition for review in the future. Mr. Hassan's fate, it seems, is with the Kentucky Supreme Court. Specifically, the question is this, quote, does Section 514.110 of the Kentucky Revised Statute require subjective knowledge or belief that the received property was stolen? More specifically, could a Kentucky jury convict a defendant under Section 514.110 merely by holding that a reasonable person would have known the property was stolen, even absent any evidence that the defendant deliberately avoided that knowledge? End quote. And so we wait, trapped in this, a 2026 battle of the wits. And that is Hassan v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.